I would like to give my sincere thanks to Mr. N.G. Sherpa, who is the director of Sikkim Judicial Academy, and also my gratitude to the deputy director of Sikkim Judicial Academy for giving me this opportunity to be the resource person before you all. And I'm also thankful to you all the advocates who have been able to attend this after sacrificing this weekend, because I know that as advocates we need a break, and especially me, I don't take dates on Saturdays because generally advocates they want to do the chamber work and all that thing. So anyways, without much delay, I would like to start today's first session. So the first session which we are going to start today is about the brief history of ICT in judiciary. Okay, now ICT, it means information and communication technology. All right, so information and communication technology in judiciary refers to the use of technology to enhance and modernize the function of courts, including e-filing, virtual hearing, digital case management, and securing handling of evidences. So the main aim is to improve the efficiency, transparency, and accessibility within the justice system. All right. So when did actually this ICT start? Was way back in the 1800s. All right. So when this telegraph was invented, after that things changed. All right. Before telegraph was invented, the people used to communicate messages through different ways, and I think you all are aware that even they used to use pigeon to deliver the messages. So over the time, there was advancement in technology which led to development of telephone, radio, television, and later computer system. So I'm going to tell you about the stages of digitalization, how it started. So the pre-digital era first was before the 1990s. All right. I see that you all are very young advocates here. So I don't think you were there during the pre-1990s era, but I think our directors have started practicing during that time. I was also there. So we have seen both sides of the coin. We have seen the computerized section also, and the hard copy section also. So the pre-digital era, which started before 1990s. So how it used to look? You can see the photograph there. You can see the pile of files. People are handling, advocates are handling. They are managing the papers out there. So basically, the pre-digital era was paper-based records, physical filing. There was no physical filing counter like we have today in the district court, and it was totally a manual process. When we had to file anything, including the plaint or application, then we used to approach the peskar directly, and at the mercy of the peskar, I'm sorry to say, we used to get the dates. Okay. So if you have good relationship with the peskar, then you used to get a shorter date. But if you have bad relationship with them, then you will get a very long date. All right. So that was how it was before this digital era began. Then the case listing, cause list, judgments, and everything was typed. There was no computer. There was this typewriter called Godrej and Brother, these typewriters. Now it has become antique. And all the documents were physically stored in the cupboard. Okay? So that was how it looked like. The scenario was like that. So in fact there was no use of computers, and there was delays and inefficiencies during that time. Because everything was paper based, alright? Sometimes what happened was even the files used to get misplaced. So when the files used to get misplaced, then there was a problem regarding that. So okay, now the 1990s era. So what happened during the 1990s? Alright, so 1990s, it marked the beginning of digitization in the Indian judiciary. So because there was growing need to manage increasing caseload and streamline judicial process. So the initial computerization started from very few high courts and Supreme Court in India. So initially, how it first started was the primary focus was on digitizing the cause list, case status tracking and judgments. Now, I would just like to share my experience. I started as an advocate in Delhi, and the number of cases in Delhi is so high, and that time there was no computer system, no digitization. So we had to go as juniors to the hall and search for our case. And the cause list used to be so thick, it used to take at least half an hour to search for our case, in which court it was listed and in which number that case was listed. But now, after the digital era has begun, everything is in your phone. Aren't you glad that now, because of the digital era, you don't have to, go physically, go and search for all these things. So basically it was the National Informatics Center, NIC, which you call, I think you have heard of this NIC, right? So the full form of NIC is National Informatics Center. It started helping courts with the basic ICT infrastructure, right? So it was the NIC which actually started helping the courts with basic ICT infrastructure, right? So now what are the key developments in the 1990s? So the early computerization initiative started in the 1990s. So the NIC started computerizing the courts at the district level. Although in Sikkim, this computerization started a bit later, but in the rest of metropolitan cities, it had already begun after 1990s. Right? So the pilot project launched in few courts for case registration, cause list generation and basic data entry. So basically it was just the in-house thing for the court. Then we come to the manual to digital transition. So the courts began to shift from manual registers to digital database for tracking the case status. So this is, I am talking about the 1990s era. So basic software tools were also introduced to support judicial and administrative tasks. So before, again sharing my experience, there used to be the case register like this. I think you young lawyers don't know what is a case register. So this is like this. Alright, you can see in the photograph. Now, when you go to the court, you will see the right hand side, case status in computer screen. So all the court staffs and pace cards and all they maintain. Now there is no register system. Alright, so this is what had happened in the 1990s. So from the case register system, it got converted to digital database, right? So creation of judicial database. NIC helped create court-wise database for pending and disposed cases. So now there's a little bit improvement. It started to create data regarding pending cases and disposed cases. So this allowed limited monitoring of case flow and to enable report generation. All right. So these are all in-house mechanism. In-house, the court was doing all this for the benefit of the court inside only. Right. You are noticing that nothing. There is no advantage for advocates or litigants in this era. So there were some High Court projects also, some High Court projects like those in Delhi and Karnataka initiated in-house, that's what I'm saying, in-house efforts to digitize records and improve the case tracking. Right? Now, as our director sir was saying, there are the phases, the 3 phases, alright? So, how the eCourts project was launched in 3 phases. So the first phase was launched in the year 2005 till 2010. So it was called the eCourt Mission Mode project. Alright? It was launched in 2005 under the National E-Governance Plan. So it is also called in short NEGP of India. Alright? So the objective to computerize district and subordinate courts across the country. So the main objective was to computerize district and subordinate courts across the country. So what was the achievement? The key achievement was deployment of case information software, CIS, computerization of courtrooms, then availability of court information on the district court website. Alright, so this was the first phase. This was the first phase. Now the second phase. Okay, it started from the year 2010 to 2019. Alright, so they started expanding their services during this era. So the integration of judicial services with online access to judgments, order and case status. Then this is very important website, all right. Launch of National Judicial Data Grid. It's a central database for all the case data. Now there is a website I'm going to tell you later on. So if you log into this, you can find out about the entire number of cases. All right, which the entire country is handling, and how many cases are pending. All right, and for your information, there are more than 5 crore cases which are still pending in India. So the development of eCourt, then in the second phase, there was the development of eCourt mobile app which you are using right now. Then there was the system of SMS alerts and e-filing portals came up during this second phase. Alright? And there was digitization of judicial record and adoption of video conferencing, remand hearing. Now we come to the third phase. This is from the year 2020 till present. Now we are in the third phase. Alright, so this is the digital transformation. It's also called the digital transformation. Now the key role of COVID-19 pandemic, it started the boom for digital transformation in the Indian judiciary. Right, so I think for more than 2 years, because of the COVID-19 pandemic, there was lockdown and total shutdown. So the people could not visit the courts physically. And it was during that time the digital transformation took place in the Indian judiciary. Right? So during the third phase, there was virtual hearing through platform like Zoom and WebEx, and I think there are many other platforms also. So there was live streaming of proceedings by some high courts, and now I think very soon even the Sikkim High Court is about to start the live streaming of proceedings. In fact, they have already started this. Now they are in the trial phase. So very soon in Sikkim High Court also there is going to be live streaming. Then in this third phase there is this introduction of artificial intelligence tools like SUPAC, okay, in the Supreme Court for legal research. Alright, so these are now, everything is now going towards the AI. Alright, AI tools. So there are many legal search engines also, whom of course you have to purchase, but these are AI based. Alright, so I am also using some of them, and now from normal search, now it is transforming towards the AI. And in this phase 3, there was the development of paperless courts, online dispute resolution, ODR. Alright, so if one of the party is not in the station, or if both the parties are not in the station, and if they want to settle their matter through mediation or any other matter, then there is a provision that they can solve their dispute through this ODR platform. Right? It need not be that the parties have to be physically present, because I myself being a mediator, I have dealt with such situation, and we have done online dispute resolution through ODR platforms. How many of you have appeared through virtual hearing, on virtual hearing? Anyone? Okay. Senior advocates. So how do you feel? Is it, do you like appearing through virtual hearing, or do you like appearing face to face?
Through virtual hearing.
Through virtual hearing.
Face to face.
Face to face, okay.
For two things.
Virtual hearing is good, and but due to the regulation, sometimes great problem.
Yes, sir was saying something.
Yeah, for two reasons I like virtual hearing, because I did a hearing for the case which was in Soren. So my journey would be around 6 hours going and coming.
Yes, yes.
That was saved. Another thing is, suppose I happen to forget something else, I am right in the chamber, so everything is around.
Yes.
So that way it was very easy and it was nice.
Yeah, it saves time, it saves energy, and as Sir was saying that if you need anything, then inside the chamber it is handy. Alright, so anyway, it is a good experience, and let me tell you one of my experiences. So it was during the pandemic. So I had a POCSO matter in which my client was convicted for 30 years. 30 years, okay. So I did a virtual hearing, and it was in DB, in division bench. So after that, the sentence was reduced from 30 to 7. So it is not necessary, you have to appear in the court physically and convince the judge. You can sit down in your office or your home and you can convince the judge. So what I am trying to say is that, in fact, it is called hybrid. No? This is called hybrid. Hybrid means either you can do physically or through online. So you should be able to take advantage of all these things, and even Supreme Court is also encouraging that rather than appearing physically, you should, even if you appear virtually, the Supreme Court is not going to say no. Alright? So even sitting at Gangtok also, you can appear before the Supreme Court and you can argue your matter. So this is one of the advantage. So phase 3 of the eCourt project was approved in July 2023 with the focus on basically 100% paperless courts. In metropolitan cities, they have already started paperless courts, and here we are on the verge of now starting with paperless courts. In fact, some of the courts had already started before, but since we are all used to using the hard copy, so I think we have to change our mindset also, and we should go for paperless briefs and all that, So the second one is advanced e-filing and case management and AI-driven judicial analytics. So what are the key institutions of contributions is that the Supreme Court of India plays a leading role in technology adoption. So basically it was the E-Committee of the Supreme Court established in 2004. So it drives the ECT policy and implementation, and NIC and Ministry of Law and Justice provide technical and administrative support. So in conclusion, I would like to say that the integration of ITC in judiciary has transformed the justice delivery system by increasing transparency, reducing delays, improving access to justice. As we move forward, artificial intelligence is expected to further improve the functioning of the courts worldwide. Okay, how many of you are using AIs to search, do research and to find case laws and all? Okay, very few, only 2 of you, huh? No, I think as junior lawyers, you are budding lawyers and the future of judiciary. You should now, from the old system, you should go towards the new one. Try to find out in the Google and all, what are the different ways how you can search and do research through AI, okay, in doing your researches, alright. So that was it as far as the history was concerned. I hope you all understood, alright. So now I'd like to go to another topic. It is called eCourts project. We should understand how this eCourts project actually started in India. So what is eCourt project actually? You should understand. So eCourt project, it started under National E-Governance Plan, NEGP, it's called NEGP in short. And the same has been implemented by the E-Committee of Supreme Court of India under the Ministry of Law and Justice, Government of India. So this is how the eCourt project has started. So what is eCourt project? eCourt project is a mission mode project. In short, it is called MMP, aimed at information and communication technology, ICT, enablement of district and subordinate courts. So what is the objective? To provide efficient, time-bound, citizen-friendly access to justice. And what does it cover? It covers court compression, digital case management, and online services. Alright, so I am talking about the eCourt project. Now, what are the objectives of eCourt projects? Number one, to make the judicial system more efficient and transparent, to enhance citizen access to court services, enable timely disposal of cases, reduce reliance on physical records, then establish interconnected paperless courts across India. Right? So I told you that time the 3 phases of eCourt project. So first phase started from 2007 to 15. So the achievements was basic computation of 14,000 plus courts during the first phase. Second phase, 2015 to 2023. So achievement was video conferencing, e-filing, digital services. Second phase. So now we are in the third phase, 2023 to 2027. Paperless courts, cloud and AI integration. Alright, so we are heading towards all this. Now what are the major components? So CIS 3.2 core software is used for case data entry and management. National Judicial Data Grid. So public dashboard for real-time case status. If you log into this website, National Judicial Data Grid, then it has helped in e-filing system, online filing of claims, application and documents and other things. You can pay through online the court fees and all, fines and penalties. You can pay. Video conferencing, virtual hearing and remote trial facilities, and even the summons and notices can be sent via email, SMS and WhatsApp. So I was talking about the National Judicial Data Grid. It is a website, okay? Now I've given you the website there. You can just write down or click the photo. If you access to this website, you will find all the real-time data of all the computerized courts, alright? Of all the computerized courts, you will find all the real-time data. So what does it do? It tracks pendency of cases, disposal of cases, case types and judge performance also. So over 20 crore cases and 20 plus crore judgments are available here. If you did not know, that's why I am stressing on this. This National Judicial Data Grid is very important for us lawyers. So this is important tool for policymakers, researchers, citizens and lawyers. Alright. So when you open the dashboard, it looks something like this. Okay, so you can see here how many cases are pending, more than 1 year old. So this is how it looks like. So when you go back home, when you have time, you can just log into this website and see. So citizen-centric services. eCourts, what does it do? Services, eCourt services portal and mobile app. It helps you for case status, to see the case status and cause list search. Then online orders and judgments, you all are aware of that. Then when you have your cases, the next date, or whatever is available on SMS and email. How many of you receive all these SMS and emails in your cases? I think all of you. All right. So there is one another app which is for judges, not for us. It's called Just Is app. Okay, for the judges to monitor daily disposal of and pendency. So what were the key achievements? So 18,735 courts were computerized and interconnected. Case data for 20 crore plus cases were digitized. This is quite an achievement. And virtual court has been operational for petty cases like road traffic cases and petty offences. So even for these type of cases, the virtual courts are operational. I don't know whether it's operating in Sikkim or not, but in metro cities, these type of courts have already started functioning. And e-filing, e-pay adopted, and there is improved transparency and reduced case backlog in many jurisdictions. Okay, now what are the challenges? So the first challenge is there's lack of infrastructure in rural or remote courts. All right, there are courts in which even now also there is no computers. You know, if you go to remote areas like Madhya Pradesh courts and even Bihar, West Bengal, you know, so till now they have not been able to access all these facilities. And there is lack of digital literacy among the staff and the litigants and even lawyers also for that matter. And there is cyber security and data protection risks. And one of the challenges is resistance to change from traditional paper-based system to digitization. All right. Even here also, what I find is most of the senior advocates who are not very computer literate, they would prefer to adopt traditional paper-based systems. I think you agree with that. So until and unless a person is little bit computer literate, it will be very difficult for such lawyers to adopt the new way of digitization. You know? So I think that is the end of this. Do we have time, sir? Okay. So okay, now I think this will be of little interest for you all. This is role of advocates and in the e-initiatives. All right. So, okay, what are the role of advocates? So, advocates, they play an important role in adopting and promoting e-initiatives. Okay, so advocates, if the advocates are not computer literate, you know, all these systems would fail, I should say. I think that more than anyone else, the advocates have to be computer literate. And if they are not willing to accept the new challenges, the entire judicial system will not be able to, you know, move forward. So advocates, they file the cases, documents online, reducing paperwork and travel. As the sir was saying that he had to travel to Sorek, but because of the uh, online virtual hearing he could do, he saved so much of time. So this is one of the advantages, and it enables faster case registration and tracking. All right. So what are the uses of eCourts services by advocates? So advocates, they access their cases by knowing about their case status, case cause list, daily orders and judgments online, so it saves time. All right. Because before we could access the daily orders and judgments online, we had to go and see the file, and that too after much deliberation we could get the file and see the last order. But now it is so easy. It is there in your mobile phone, and you can access to daily orders, judgments online. So there is this eCourt mobile app. I think every one of you are using this eCourt mobile app. So you get the real-time updates on your mobile app. So advocates can also assist their clients. So how many of you have taught your clients how to use that eCourt app? Have you? No? Okay. Ms. Nautara.
Client was in Chennai, so I had to inform them regarding the web,
Yeah.
and accordingly they could access.
It is good to teach your clients also, so that they can know what has happened on the last date, and they can keep a track of these things if your clients are computer literate. So again, coming back to the same thing, advocates, they participate in hearings remotely via platforms like WebEx and Zoom. Okay, so what happens, again coming to the same thing, it saves travel time, especially in High Courts and Supreme Court matters, and you can appear from your chamber also. Right? So before that, I think there is a must for legal education and training for advocates and court staffs. So advocates as well as the court staffs. In fact, I was told that the court staffs would also be coming today, but I don't see any court staffs today. So anyways, advocates as well as court staff need to do the ongoing digital literacy training. Okay, so in fact phase wise, because new things will be taught, and after every few years, there is going to be a transformation. So if you stick on to the old way which you have learned, that is not going to help you out. So advocates also need to participate in judicial training programs related with eCourts. All right. So senior advocates need to mentor juniors and clerks in using digital system. In fact, I find it the other way around. I think the junior advocates, they in fact help the senior advocates. Is it true or not? Yeah. So how many of you, I think every one of you know regarding this e-Seva Kendras, no? E-Seva Kendra, it is one is there in the district court also, and one is there in the high court also. So e-Seva Kendra is basically for those who does not have access who does not have technical access. Alright, so you go there and they will help you regarding filing and all these things. Okay. So I think I am at the end of this session 1. So advocates, they play a crucial role in successful implementation and adoption of e-initiative in the legal field, and they act as a medium through which the e-court system becomes successful. All right. So is there any, can we have an interactive session we can learn from each other? Anything you would like to share your experiences or how this eCourt system has benefited you?
So for me, there was advantage as well as disadvantage. I think so was also the case. It was around already 6 o'clock.
Wala mic please.
The judge said, no, we have to take the...
Can you come again?
Yes, sir. We had one matter during, I think so was also one of the counsels in that case. And in that case, the matter was not taken up during the daytime. It was already 6 o'clock and we were all at home. So the judge said we have to have the matter conducted, and it was for hearing. And since there was a senior counsel in my case, was not able to attend, and all of a sudden I was asked to think. But I had no papers, nor the case file, nor any of the material regarding the case. Only what was in my mind, I remember, because it was regarding a matter of property, and it was of 1975, and I just remembered some dates of Sikkim getting merged with India, and that time, before that, the property had been transferred. So, keeping those few facts in my mind, I tried to, but paperless also, like if I didn't have the papers also, but it was my mind that was working. So, without paper also, without computer also, we can still work. Because I didn't want to say that it should be all digitalized only. If you have like in your mind also, you can think you don't have to depend on papers also. So that case was conducted, and the results also, I think so was also then arguing, and we had some senior lawyers. But the matter took up and the judgment was passed also after a few days, and I was happy that it came in my favor. So yes. I say that it's not always we should depend on digitalization of matter or going through computer or Zoom, because sometimes internet facilities also don't favor. We have heavy rains, we have so many kind of problems that we come across. So always I don't say it's like favoring us.
Okay. Anyone else?
Yes, sir. It's a great plus for me. All these things, there are some setbacks, but then they can be all overcome in the future days because technology is advancing, and we are also adopting the new technologies. Wi-Fi, the internet system is now improving. I hope in the days to come it will be very, very efficient. But some of the things that we adopt as our practice in eCourts or e-filing system is little bit complex, because what I realized, when we had to type and prepare all our documents, and then we had to make our clients come and sign over that. Now after that, we have to take pictures of them, or we have to scan them, prepare a separate document and submit it to the court. Whereas physical filing would just be, once you make the client sign over the documents or whatever plans, then we can just file it. But here we have to do again scanning, and that scanning machines, and not all the chambers have. And for that we need to go to the e-Seva Kendra, and there we have to do things like that. So it's a lot of extra work, a lot of hassle for the advocates, especially the junior ones. So if we could only submit the soft copy with some declarations here and there, that could help us. But I don't know whether that has already been done. But when I was doing last, that was the stage we were in. So, thank you.
Yes, anyone else?
As my viewpoint, and I have faced as well, it really helped me during especially the COVID times. I realized it was very good, but at the same time, as I believe, we should not totally rely on digitalization as well. So we can take it as an assist, we can take it as a supportive factor, but we should not like 100% depend, because what happened, sometimes we feel very like, the lazy in like to do in digitalization. As I said, we will not get that the court environment when we do the hearing whatever in digitalization mode. So I think there is a plus point, but 100% and totally rely on digitalization, it's not favorable as my viewpoint. Digitalization.
And what is the reason for that?
It's easier for us to access a lot of things, easier to do the filing process, and also easier for us to track. That's it.
You can access to judgments, orders. Yeah.
म चाहिँ दुईटै सपोर्ट गर्छु। The reason is that digital was के भन्दा when we filing गर्दाखेरि चाहिँ हामीले चाहिँ what we facing the challenges भन्दा चाहिँ there is some time shortage हुँदो रहेछ. Once we log in the e-filing, there is only the I think half an hour दिन्छ होला सायद e-filing. So सरले भने जस्तै, so we have scanned all the documents and we have create separate folder, है त्यहाँदेखि बादमा e-filing गरिसकेपछि त्यो स्क्यान हाल्दा हामीले फेरि फर्स्ट अफ अल e-filing गर्दा पहिला छान्नु पर्यो कोड कुनै के गर्छ डकुमेन्ट्सहरू हाल्दा कोहीलाई त ढिलो भएर टाइमै हुन्छ। फेरि अगेन लगइन गर्दा त्यो फेरि कति 1 आवर या 2 आवर्समा चाहिँ उयो टाइम अफ सक्दिँदो रहेछ। सो समटाइम के हुन्छ भने यो भन्दा त डाइरेक्ट गर्दा वी गो टु द कोड एन्ड फिजिकल फाइलिङ गरेर छिटो हुन्छ जस्तो लाग्छ फेरि हो। समटाइम के हुन्छ भने हामी फाइलिङ गर्दाखेरि चाहिँ त्यो भटाभट हुँदै गर्दा ओ यो सजिलो रहेछ भनेर सोच्छ हामी चाहिँ। सो द्याट आई थिङ्क द्याट त्यो टाइमिङ र उयो e-फाइलिङको चाहिँ कति एप्लिकेसनहरू इम्प्रुभ गर्यो भने चाहिँ आई थिङ्क द्याट सबैजना इजी एक्सेस हुन्छ जस्तो लाग्छ मलाई चाहिँ। द्याट्स माई थट।
Yeah, I feel that this digitalization is a kind of, not totally reliable. We use paper to file our briefs, right, in the court, but at the end we file it online. What I feel is, if we had to use paper, if we have to make it fully digitalized in today's era, we have to do it in a 100% basis. As in, we have this concept of digital signature and electronic signature. If we are filing it on paper and signing it over there, why not make it fully physical? And if we are filing it online, we have to make it fully online with the digital signature and the electronic signature. There's a loophole, a very big loophole in this digital thing. Last time I was in this, one-day orientation program on IT Act, and there was this term hashing that we need to do while collecting evidences.
Yes, I was also there.
Yes, so you know, sir, that it's a loophole that a defense lawyer could have while, demolishing the witnesses in seizure of evidence. So coming back to this eCourt filing system, I feel that rather than digitalization of everything, one should know the technical know-how about digital signatures also, or else how could we verify whether the thing is authentic or not? So yes, I support paper, both in a sense. Yeah.
In my opinion, it's better that there's access to it like, rather than physically being present in the courtroom, or like, you know, where you file the things. I mean the documents and filing stuff. But then I feel the whole software could get better. People could code better, because a lot of times the order sheets, when we actually go and try and take it out, there is more of a software issue most of the times. So I think that's it.
Yeah.
In my opinion, I think it's like, for me it's like 75%, because like, I feel like we're not like, I can't trust 100% because not everything online is like true. Because like you could have like errors out there and then you could just put up, but it couldn't be like 100% true. But like how Sir mentioned about the time limit, I feel like time limit would be better, or like more of like, there shouldn't be any time limit, because like, you know, you can, sometimes you have your network issue and all that. So if there's no time limit, it's better for us, I feel. So you know,
Okay.
things could be done easier and then it would be easy for all of us.
No?
What I feel is that both should go hand in hand. किन भन्दा चाहिँ अब यो अनलाइन त जति पनि छ यो सबै एउटा सिस्टम हो नि त. वाट इफ टुमरो अब केही भएर फ्युचरमा यो सिस्टम सबै क्रास भयो भने त 100% हामी रिलाइ गऱ्यो भने त त्यो टोटली हरायो नि त. अन्त इफ अब त्यो अफलाइन पनि फिजिकल पनि प्रेजेन्ट हाम्रोमा छ भने चाहिँ रेकर्ड छ भने चाहिँ
Can you hear me?
Sir, digital filing, it looks so attractive, but that is not the case. The attractiveness should not be a magnet to attract us. It should be like something when we do physically, especially hearing. At least we mention about the judgments and we are not certain whether the judge is noting down the judgments which we are trying to quote. So we feel a little bit disturbed.
Okay, now you guys are talking about the filing of claim and filing of appeal and all that. Okay, now in title suit, what happens? You are basing your case on certain documents, right? So if you file only the digital copy of those documents, how you can prove, as per the Evidence Act, how you can prove the document? So that is also one of the problems. Because see, along with the claim, you have to find the original, because CPC also has not been amended regarding this. There comes a stage where there will be issues and documents. Documents means filing original documents. So if you keep on relying only on the digital thing, that is not permissible. Court will not allow you. So these are some of the challenges. Now even the other acts also has to be in consonance with this digitalization. Yes. So there are some problems. Anyways, now I think we are just in the teething stage. So I think this is for the first session. I think we can take a break now.
Sir,
Yes.
sir, I would also like to
Yeah, please.
share.
Yeah. Sit down, sit down. Please sit down.
Regarding this e-Sewa Kendra
Yeah.
in every court, there is a e-Sewa Kendra, but what the problem actually we junior face is that recently I have filed 3 claims in the same day. It's till 1 p.m. only, the time limit. It's mainly a time consuming. And the problem that we face regularly is that the e-Sewa Kendra is usually engaged and we could not complete our filing within 1 p.m. That's the main problem we junior face. First of all, yes, as ma'am said, I accept that everything has its advantages as well as disadvantages. But it's like more disadvantages for only for the filing session. But regarding other sessions, like you can present through video conferencing, that's always very good, and it's like mostly efficient for the filing. But what the problem is, it's mainly we are from a hilly region, and there is like weather ko hamro usma we cannot guess what the weather will be and how the internet will work. Main problem we face is internet. Networking is the most disturbing during these phases. And, sir, the main problem that we face in our daily life is like, जुन चाहिँ हामी फाइलिङ को लागि जान्छौं, स्क्यानिङ एरिया चाहिँ अलरेडी एंगेज हुन्छ. सो जस्तै मैले भने रिसेन्टली 3टा प्लेन जुन चाहिँ मैले फाइल गरे, त्यो टाइममा चाहिँ एभ्रीथिङ आई हैव टु स्क्यान थ्रु माई फोन. That's really like total of 350 pages, जुन चाहिँ इम्पोसिबल हुन्छ हाम्रो लागि पर डे, किनभने एउटा स्क्यानिङ गर्दाखेरि सानो मिस्टेक आयो भने पनि दैट प्लेन गेट्स रिटन, किनभने त्यो हामीले फाइल गर्न सक्दैन. त्यसैले गर्दाखेरि हेर्दाखेरि मेरो लागि चाहिँ यो भन्न सक्दिन कि यसको चाहिँ एडभान्टेजेस मात्रै छ भनेर चाहिँ भन्न सक्दिन, तर साथसाथै डिसएडभान्टेज मात्रै छ भनेर पनि भन्न सक्दिन. म चाहिँ एउटा यस्तो प्रिफर गर्छु कि यसलाई चाहिँ म 50-50 मै राख्छु. किन भन्दाखेरि चाहिँ विथ माई एक्सपिरियन्स है, जुन चाहिँ यो छ हामीले यसलाई एडभान्टेजेस मात्रै हेर्यो भने पनि हुँदैन, डिसएडभान्टेजेस हेर्यो भने मात्रै हुँदैन. हामीले चाहिँ विथ टाइम यसलाई चाहिँ प्रोग्रेस गरेर लानुपर्छ भन्ने म छु. थ्याङ्क यू सर.
Whatever the internet connection and all, but as compared to our state, which is comes under the hilly areas, and there are so much of issues regarding the networking system. I think here it takes a little bit of time to assess all these things. Only then we can say that we can totally rely on the digitalization 100%. I think nowadays, so far, we can take it as a kind of assistant, not totally.
I think we can take it.
Yes.
Right now, we're going to start a second session. And in the first session, we are just seeing the advantages and disadvantages of eCourts and e-filing and all. So we have got your feedback. So now, in this session, my first topic is eCourts services available to advocates. So first, we'll just start with the introduction to eCourts. So what is eCourts? So eCourts project is a mission mode project under the National E-Governance plans, which is in short called NEGP. Alright. So this was launched to digitize and streamline the entire judicial system, and it aimed at providing efficient, transparent and accessible justice delivery system. And the advocates are the key stakeholders in this digital transformation. So what are the objectives of eCourts for advocates? Firstly, it provides real-time access to case information. It minimizes physical visits to court. It enables efficient case management and updates. It ensures transparency in judicial process. it reduces paperwork and delays. Okay, I'd like to pause here for a minute and let us have an interactive session also. One point which was I was telling you is it ensures transparency in judicial process. Okay. Can someone tell me how does eCourt services ensure transparency in judicial process? Let it be an interactive session.
We are able to see everything online. The step for the court or the case.
Can you have your mic, Dinesh?
We
You can sit down.
are able to see everything online, even the steps taken from the court or any of the parties, we are able to see there. Even the order sheets are available, including the judgment. So that's how it's very transparent in the transparent process in the judicial system. That's how I understand.
Anyone else? Yes or no?
So probably it's more transparent because everything is available online. So like if I want to see the cause list, it's available online. If I want to see the order sheet, it's available online. So there's transparency because it's available to all the people at the same time, so they can access it. So that way I believe it's more inclusive. The eCourts is more inclusive, and I believe we do not have to visit every time to the court. Things can be seen from the in our house because we have connections, we have internet. That way I believe it does make it very transparent.
Yes.
So the antonym of transparent is opaque. So it is withholding information in many ways. For example, I may say to my client, okay, today this is what happened. But once it is there, right before him, he knows whether you are present for his case or not. That is being transparent, right? So he knows what happened in the court today. He knows what were the submissions that you kept before the judge. Those things are all recorded. And also for the lower court and those subordinate judges will also be accountable, because the high court judge or his superiors, even for that matter, any superiors in this judicial system, if he has to or she has to actually see and inspect the work of the junior, whether it's going okay or not. It is easily available. For example, a high court judge does not have to go and ask for the things. It is right on his or her fingertips what is going on, how it is going on. So that way, I think a lot of transparency has been actually, can be attributed to this present form of our, digitization of the courts. I think that way it has become very, very transparent.
Good or bad?
Definitely good. Definitely good.
But you can access the orders of the other cases also.
So, sir, actually the CRPC in section 244 said that the courts have to be an open court. So, if the courts have to be an open court...
No, it has to be an open court, okay. Till the proceeding, you are sitting there and you are seeing the proceeding, that's okay. But digging into someone else's file and reading the orders, is that...
So, if you are digging into somebody else's file, that's a problem. But then if I am doing it for research and for learning, then I think it's not a problem.
Both sides raise the issue of privacy, no doubt.
Yes,
It does raise
that's what I meant.
Court records are public records, so it does not hamper anyone's
Except for some
privacy.
sensitive cases, if it is POCSO.
But I think POCSO cases, orders are not reflected.
So that does give
Even the
you...
name is not.
Names are not reflected.
Yeah, by Arun, bonus now. Let us
or you have to speak in the court?
You should take part.
You have to speak. You have to speak. What do you think about eCourts?
Yeah, say something.
eCourts are the information available to all the public. Here, anyone can get the judicial knowledge and judicial orders and whatever the cases are going on everywhere. And if the public has the information to all the every information of judicial things with them, then it is a transparency in judicial services, sir.
I think family court matters are not made public, right? What about domestic violence cases?
It's a camera procedure.
It is.
Juvenile orders are not there.
But domestic violence cases are.
And we are filing it physically.
No, the orders.
ED cases orders are available on eCourts, but then your family court is not.
So don't you think that it's a matter of privacy?
Yes, it infringes someone's privacy. They don't want things to be better, especially TV monitors.
So there can be a procedure in which there can be a filter on eCourts that decide that such kind of cases should not be shown to all the people.
There can be, but till now it is not there. So I think you all are aware of this website, and I think you all have logged into this website and you have done your case status research, search by party, advocate. I mean, for the young lawyers who are here, how many of you all have logged into this website? Okay, mostly all of them. Only the front row have not, right? So if you want any information regarding your case, you have to log into this website and you can get the court orders, judgments, cause list, filing dates, next hearing dates and all that, okay? And I'm sure you all have also downloaded this app, eCourts, in your mobile. So through mobile also you can access the case status, daily cause list and all that, alright? So I've already talked to you about National Judicial Data Grid. The website is here, and when you go home you can just log into this and you can search for even your cases, and as I told you, there are more than 5 crore cases which are pending in India. So e-filing system, I think most of you are aware. So there is a platform for online submission of legal documents. How does it help you? It enables you uploading your petitions, case appeals, affidavits. You can file it from any location. And digital signatures for authentication. So these are currently available in many high courts and district courts. Virtual hearing basically is the repetition of what I've already said in the morning, but the topics which have been given to me is basically I'll have to repeat the same things. So virtual hearing and video conferencing. Do you agree and do you accept that if a witness is examined through video conferencing, is it beneficial for you or it is not beneficial for you? Can you Can we discuss on this?
It's not beneficial.
Any witness who was not present in the court.
It's not beneficial.
Not
Not beneficial.
It's actually not convenient. And sometimes, I mean, it is convenient because if you cannot come, then yeah, it is convenient. But then when we are examining the witness in front of us, it's easier to use our theatrics and tactics.
So if we are examining the witness,
What they are trying might be
Yeah, take the mic.
about to speak.
if we are examining the witness through VC, the witness can be tutored behind the camera. That is the so yes, the VC is dangerous for examining a witness.
But there is a notification of the High Court that coordinator has to be there.
Yes.
Alright, but I don't think we are following it yet.
Coordinator can write.
Because in one of my cases, the witness was sitting in a vehicle and she was, giving evidence from there. I raised the objection, but I was not right. Objection in the ground that coordinator has to be there. So I feel that examining the witness through VC is not beneficial for the lawyers.
For justice.
As far as hearing is concerned, I think that is okay.
Yes.
You are not standing in front of the High Court judge and you are in a relaxed mode.
But 2-3 hearings, if they are doing virtually, then sir, even the court says that you better be present.
So in that
in
also I
person.
think we are not able to put forth citations as well as the points which we want to, because we will not know whether the judge is trying to note it down. If we are in physical courts, we feel the judge is okay. We can feel some kind of face-to-face that, okay, our answer might be noted. But when it says video conferencing, it's a different story.
Because at the end of the day, so many things depend on the mood of the people also. No? Now that supposedly the network is bad, my client suffers.
What the most important is India does not have to be network even now. So the thing with workspace.
Yeah, I faced this problem during the pandemic, and I had this problem, network issues, and even the court also has. In fact, more than me, the court had network issues. So the date had to be adjourned. And as Yosan sir was saying, that of course through VC you can reduce the travel time and you can save time. So the tools which are used is through WebEx, Zoom, etc., which is integrated with the court system. And additional services to the advocates, you can pay your court fees and fines through ePay. You can download the judgment and orders. Certified copies, copy request made online. I don't think this facility is available here, right? Certified copy.
It's not available.
It's not available.
Sir, what is the legal standing of an affidavit when I am filing an online petition and it does not have a stamp, because then the registry says that the stamp is not required. In that case, what is the legal standing of that affidavit?
Because the rule is that you have to make the payment online, even while filing wakalatnamas also. Because generally,
but then does that affidavit stand, sir? Because affidavit without stamp,
no, the High Court is accepting it.
that becomes legal by notice.
Yeah. So, in conclusion, the eCourt services promote transparency, as we have, whether good or bad, transparency, speed, convenience, and eCourt services has lessened the burden of advocates to a great extent. How many of you agree to that? It has lessened the burden of advocates, eCourt filing.
No, it's increased.
It's a very complex procedure. So I believe the previous e-filing was a little easier than this one.
The version 3.
Another problem is once you file in the High Court, it goes into defects. Now, defects are not shown in the defect box. It is shown in the view status box. So if you don't go and view status, supposedly I am not known to it and I don't go and view the status, I will not even know that defects have arrived. So then I got a call from the registry. That is how I realized that we have to first go to view status. Then there the defects are there.
So how many of you have been able to file your petition or whatever appeal in the High Court without any objection?
That has never happened in the history.
Even an adjournment petition comes with many defects.
So,
only rejoinders. When there is no document to be placed, nothing simpler than that.
I have filed only wakalat now without objection.
someone was saying, I think it was in our case that someone filed and there was an objection even in the Wagalam.
That's a great achievement.
Achievement. Okay. So we move on to the next topic. So what are e-filing versions? E-filing, you know that it is called electronic filing. It's a process of submitting legal documents to courts by using electronic means. Okay, so need for e-filing because of overburdened courts, long delays in paper-based filing, need for contactless system, especially during the COVID-19, and it's a part of Digital India and eCourt Mission Mode project. So, okay, the first eCourt, it was version 1.0. So it was launched in the year 2010. Okay, it was on a pilot basis. So what were the features? Basic online submission of petitions, limited courts covered, mostly high courts was covered. So there was manual scrutiny and physical hearing was still required in this version. Okay, so they had to do manual scrutiny and the physical hearing had to be done, and the lawyers were supposed to go to the court and argue the matters. So what were the limitation? No integration with court records. User interface was not friendly, and there was no system of OTP or email authentication. This was regard to version 0.1. Then came version 0.2. It was launched in 2015 and 16. So it was a part of second phase of the eCourt project. The features were digital signatures were supported, online scrutiny by court registry. So this was during the year 2015. Then case status and cause list integration. Then SMS, email alerts to the parties was made available. And it was more secure and faster. Then came in the year 2020-21 version 3.0. So the highlights were unified platform across India. Then the CIS integration was there. So filing by both advocates and litigants in person. So even litigants in person also could file. But is it practical that the litigants in person, if they file, is it practical? What all do you think? Their case?
A private company. Only a private company. a litigant.
But without a lawyer, how far is it feasible?
Not advisable at all.
But if they know the process of the digital filing, e-filing, they do it.
Then after the case is registered, then no, I don't think this is practical because okay, filing they will do, but when the case is registered in the court, don't you think that they need a lawyer?
There might be an exception where a person might be very thorough with the procedure, they will be a seasoned litigant. So in that case, they might know what to do or what happens in the court. And in such situations, perhaps they could. But that is in exceptional cases. But for most cases, I think you do require a lawyer to represent yourself in the court.
So in such cases, there is 100% guarantee that that person will lose the case without a lawyer. What do you say? So there was this provision for uploading of annexes, affidavits and payment online, and mobile compatibility was there in 3.0. Then came 4.0, which is we are using right now. It was launched in 2023. So the key features are multilingual interface, Hindi and other regional languages also are there. Real-time integration with eCourts, e-payment and all this are there. Then AI-based scrutiny assistance, e-summons via WhatsApp and email, SMS. You know, when you file your case, then they ask for the phone number for of the opposite party. Yeah. So basically, it's to send through WhatsApp or SMS. So dashboard for judges and registered advocates. So basically, this 4.0 is a user-friendly and easy to navigate, and it has a responsive layout. So 5.0 is going to come in future. So what it provides? AI for document drafting. So blockchain for document security, which means that the documents cannot be tampered with. Why? Because the computer system is linked with one another. There are 4 or 5 computers linked with each other, and because of that, if one computer tries to manipulate it, the other will catch it. Alright. So this is called blockchain. And there is going to be voice-enabled filing system also. And mobile apps with vernacular language support, biometric login. Just now, I don't think you have biometric login. No. So biometric login. Then smart scheduling for hearings. So this was regarding the e-filing version. Okay, so now I am moving on to another topic, importance of e-filing. So basically, as I have been telling you, it's just a repetition of the same thing. Since these topics have been given to me, so I have to repeat these things. So, e-filing introduction is a process of submitting legal documents online. You all know that. So it replaces the traditional method of submitting physical copies at the court registry. It is a part of larger e-judiciary and digital governance initiatives. Okay. So the objectives of e-filing: to improve efficiency in case filing, reduce paperwork and manual errors, ensure transparency and speedy redressal. So what are the benefits for advocates and litigants? You can file it from anywhere and anytime. You can track case status in real time, receive instant acknowledgement. It saves time and resources. Secure development, document storage and retrieval. So what are the benefits for courts and administration? So it reduces physical handling of files. Now, how many of you agree to the fact that e-filing will reduce the physical handling of files? Do you think that it really reduces?
We are always carrying a file. Even if we have filed it online, we are carrying a file.
No, this is for benefit of court and administration, not your benefit.
They are also always carrying a file, sir.
Who's having the case files? So it manages it streamlines the case management system, and it ensures better record keeping and archive. Do you agree with that?
At High Court level, so this does help, because High Court, every petition that we file is available on the screen when we are going to argue the matter over there. But at the district court level, I think this does not help much.
No, even in district court level also, now all the disposed files also, they're scanning it and they're keeping it, this thing, in their computer.
So district court, what we have filed, we do not see it online.
No, the disposed cases. Disposed cases. So it reduces the burden of court staff. How much of you agree to that?
Little later if we...
Because they have to
eventually
computerize everything.
Right now, I think it's going to be more taxing because they have to get used to it also.
They need more people to work. And experts are available.
So, legal framework supporting e-filing. Now that time I was talking regarding documents, whether if you file. Now, this IT Act 2000, it gives validity to electronic records. Right? So section 4 and 5 of the IT Act. Okay, so electronic records and signatures are legally recognized and hold the same validity as their paper-based counterparts. So you know about secondary and primary evidence, right? So there is this. So as per the new BSA and the Evidence Act also, if you file this application under section 63 and 65, so it gives legal validity. So how e-filing works? I think you all are aware of this. That time I was showing you that e-filing portal website. Upload the petition. Then you have to pay the court fees digitally, submit electronically, track case status and receive updates. It sounds very simple, no? How simple is it? So e-filing is a key step forward towards a transparent, efficient and citizen-friendly justice system. Right? So I am done with this topic also. Coming to the next topic. The advantages, advantages. Okay, can someone tell me what are the advantages of e-filing before we start?
You don't have to give to the tantrum sometimes of the court so that filing is only till 4 o'clock. I'll file it at 4 o'clock, 5 o'clock.
1 a.m. or 2 a.m.
I have
Middle of the night.
No, but
the only advantage is that you can file it when you and then wait for the
hoping that
it comes.
there won't be any defects.
Prompt response.
So time-saving benefits, e-filing, speedy and efficiency.
So it is not speedy if we have lots of documents because we don't have that scanner which the eCourt office has. No, they scan very fast. Our scanner, one scan in 7 minutes. Then it is a very difficult task if you have to scan 20 pages.
Then you'll have to tell your client to buy that scanner. Yeah.
You have to buy that scanner.
Whoever has bulky documents, you tell him to buy a scanner. So, instant document submission without physical travel. Automated processing reduces turnaround time. Real-time acknowledgement and tracking of submission. That you agree. So, cost-effective. How many of you agree to that?
We have to print on the
Cost-effective.
So similar thing like printing, posting and all, still we'll have to pay.
Yes.
When we go for the even newspaper printing, we have to print.
Here they are saying saves on printing, postage, courier and travel.
We agree with travel.
Travel also.
Printing you have to print, no?
Yes.
We have to do.
Yes.
And again we have to
Upload.
Postage also you have to do so many times.
Lots of printers even printing.
They'll tell you to post it for
one
5
copy will be
times.
enough and others will
Especially
send
iPod.
No, but printing also, if you just have to print one set only, one original only. You don't have to print. But what about giving it to the respondent? They will ask for hard copy only.
Yes. And ask
If
the office also needs
you
it.
if you mail to the prosecution, then they will tell you to give the hard copy.
They need to be educated.
Yes, sir. Actually, I think.
No, they don't want to use the government paper. No? Reduces administrative burden for both users and government department. You agree to this?
After proper implementation of this.
So no.
As of now, we cannot say.
So they'll be more happy, I think so, but I don't think so.
Then long-term saving
This is
in.
good. Yeah, saving in storage. This is a good thing.
But someone was saying, what if the computer crashes?
No, but this is in the central record. I think.
No, not necessary.
But you can save it in cloud.
After 100 GB is very costly. After 100 GB very costly.
That message is coming to me.
People will carry the whole system and walk away.
My Gmail is showing red.
And
I have 5 accounts.
some cloud has no space also.
So if we are storing it on cloud, will it be hacked?
Yes.
There's always possibilities that the cloud can be hacked.
Yeah, it can be hacked.
That's why
So it can be accessed anytime, anywhere.
if net is there.
Users can file documents 24/7.
And managing multiple jurisdictions.
This is nice.
From any location with internet access. This is very important. With internet access.
Yes.
Suitable for professional managing multiple jurisdictions. Yeah, this is important. It enables access to filing history and previous records easily. Transparency, we have already discussed that time. So electronic timestamps and tracking improve transparency. Users receive confirmation and status updates. This is okay? Minimizing chances of manipulation or loss of records. What do you mean by manipulation if you do e-filing?
Manipulation would be something around tampering.
So how does it help you, e-filing?
Because once we have already uploaded, then that record will always stay. So supposedly I am trying to change something. So when it is compared with the first record, it will be, I think, easy to track that something has been changed. Probably.
But earlier what used to happen, sir, case was filed, documents filed, particular document not filed, immediately they used to go to the record room or go to the office records and insert those documents. Despite the other side has already got the entire set of the case papers, but it has happened. But in this, if it's, the transparency will be little more because we file it along with it and those documents cannot be removed. But only thing if there is some changes or there's scratch or something, that can be when records can be called for. What can compare with the originals.
So there can be tampering of documents also. Supposing if a document has been filed and if they want to change the date or name or anything. So if there is no this thing, scanned document filed, then it becomes easier to manipulate the document. But after, as Abhinav was saying, yeah, scanned documents cannot be tampered with. So accuracy and error reduction. Forms often include automatic checks and prompts for missing fields.
This is the biggest disadvantage. Missing fields is the biggest disadvantage. They want us to fill all the forms, whichever is red marked. And sometimes you don't understand what to fill in.
What you did not understand?
For example, there are 7 to 8 sections that we have to first fill to file a record. Now supposedly it's a civil case. Then also they are asking for FIR number. But now it is not read. Previously even that was read. So you have to enter something into that field, only then can you proceed. That becomes a problem.
No, but I think now they have improved it. No?
I consider it improved.
So, but what about this automatic checks? They will be checking the document you file and then they'll compare it with the
automatic checks.
computer.
No, it is if you don't fill that part, and you submit, then the computer will tell you that this field is missing. That is automatic.
If you don't fill up the entire thing, and if there are missing fields, then they won't take you to the next. That is the thing. Okay, reduces chances of human error compared to manual filing. Huh? Only this group is interactive. What about you all?
They do their maximum.
What do you have to say? Reduces chances of human error compared to manual filing. Do you agree to this?
It's the same thing. Same document is filed. So only Defects are the same. We have the iCourts
Second point
very
is
all
more scrutiny. It reduces chances of human error.
Our iCourts.
You have to be more careful, right? You are telling.
Either way, they have to
The
be.
controlling, they have been computerizedly controlled.
So easy corrections and resubmissions.
Agree.
Correction.
ठीक है?
Easy then.
Easy correction, I again have to go to the source document, change it, print out, again go and scan, and then it can be corrected.
Mainly what I feel is the main idea of e-filing was to make it paperless. If we are not doing that, then what is the purpose of having an e-filing thing? The defects that arises, we have to change the paper. More paper is being wasted in that thing. So this is totally, until we know the technical know-hows of digital signature, this electronic signatures, other documents we have to file it online. There's no correction to be made in documents. So we can file it without wasting any paper. Apart from that, the petitions, if we are getting any defects in the petitions, then we have to change papers after papers.
Yeah, that is that.
Defeating the very logic of e-filing.
So environmental impact that you will all agree.
Very much, very much.
So since you are not using papers, so
So I think that the next development that they have to make is that once we make it a document, we don't have to print it. Directly we can upload it from the source computer. Then it is helpful.
Yes.
Then you bring in digital signatures, then it is helpful.
but is it possible?
Yes, sir.
Yes, it is possible.
It could be possible. CA
Provided we are a little tech savvy with it.
the interface that they use, that is possible. They don't even print it. The Microsoft document is ready, they make it into PDF, they upload that PDF. They don't print it and then...
What about the signatures?
Digital signature.
Digital signature, we have to purchase it.
Okay.
They are probably more advanced.
And the documents which you file along with the case?
Documents which are already there, we need not change it again and again.
What will they do?
That is what I was saying. You have, while filing a civil suit, then you have to change the CPC also.
Yes.
And issues and documents, what happens in that? Court will say where is the original document.
No, sir. The documents which are already there in hard copies and which we are using it right now, physical, until the whole ecosystem has been electronic, and documents also which we are signing, suppose a agreement which we are signing electronically, along with all the electronic signatures or digital signatures, we need not file the original after that, because the agreement per se is made electronically.
No, I am not talking about the agreement, but even in a civil suit, if there is an old document, okay, one document of 1952 parcha, what will do? Court will tell you to file the original.
That we file it. We cannot do make new copies, electronic copies of the old parcha which is already there. But what we can do to fully revolutionize this thing is that we adapt to this electronic ecosystem and henceforth start making our documents also in electronic way. Starting from agreements or parcha.
See, dealing with civil cases, the law is clear that the original has to be filed, okay? So unless there is an amendment in the CPC, okay, now you are able to file digital copy of that. So just scan it and file it, but the law should
be amended first.
Permit you, no, to file that.
DigiLocker should also be used.
Pardon?
DigiLocker is a platform which consists of all the documents in itself.
DigiLocker is acceptable, even in IT Act, it's acceptable.
Which can be used with eCourts.
In DigiLocker, what documents do you have? Only the government records, no? Parcha, I don't think you have it as well. In DigiLocker.
So security and data protection, encryption and authentication mechanism protect sensitive data. You agree to that? What someone was saying, if there is a hack, then so access control through user credentials. This is yet to come. This is yet to come.
No, I have a number and password, so that user can only I can access my so that will.
Backup and recovery system ensure data safety.
It's dependent.
You agree to this? Backup and recovery system ensure data safety.
Yes.
No.
Sometimes it doesn't go for backup. We say, we just have it dot is backing up. We don't even get that is backed up on it.
In your computer?
In my systems also, not only mobile also.
It doesn't back up.
Not all. There are certain documents.
So I think I'm done with the second season also.